afternoon. My name is Oliver Westmoreland. I am an OSC registered level 3 immigration advisor and I am senior immigration lawyer at GSN Immigration. Please subscribe to our YouTube channel and click on the bell icon so you can continue to watch our extremely interesting videos about UK visa and immigration advice. Today's topic is the new £29,000 requirement for sponsors under Appendix FM. We have publicised this a lot on our blog, on our website. It has now come into effect on the 11th of April. I want to talk about it and how it works, and hopefully how it can work if you don't meet all the requirements of the rules. I'm going to introduce a commonly known technical term, Appendix FM, Appendix Family Members. This is a very important part of the UK immigration rules. It's about all kinds of things, really. Particularly for today's discussion, it's about partners, spouses, civil partners, unmarried partners. It covers other categories as well, but I want to concentrate on these. You have applicant and sponsor. The sponsor is the person who is in the UK already. The applicant is the person who's applying for a visa from outside UK or possibly from inside the UK as well, but it's the same. The applicant is the person who's applying for the visa. The sponsor is the person who is could be British, could be settled, could hold leave under one or two various different categories, pre-settled status, stateless person, etc., etc., etc. That person is the sponsor. The requirement about earnings is like this. If the applicant is applying from outside the UK, the sponsor in the UK must be earning so much. If the applicant is applying within the UK because perhaps they already have a partner visa or they have some other kind of visa and they're applying to switch their visa, either way, earnings of both parties can be taken into account, sponsor and applicant. Either way, it's got to be satisfied. As I said at the beginning, since 11th of April, this big jump in the financial requirement occurred. Big jump indeed. Certainly in nominal terms, the requirement previously was that the sponsor or perhaps both parties earned at least £18,600 before tax per year in the UK. If there were children, there were extra requirements, more requirements. New rules are simpler, but perhaps a bit on the high side. New rules from that date. Either the sponsor or the sponsor and applicant must be showing earnings of at least £29,000 before tax per year. However, if there are children, there is no extra requirement. So in that way, the rules have been made softer, but of course, 29,000 is quite a big jump from 18,600. In the economics department of GSN Immigration, we've done some very sophisticated calculations. We find that this is actually a real terms increase. It's not just a large nominal increase, it's a real terms increase. Now, you may or may not know that this figure of 18,600 was fixed in 2012, which is a long time ago. There's been quite a lot of inflation since then. However, even taking that into account, this is a fairly substantial real terms increase. I strongly imagine, I mean, we work in London, we might find quite a few people in London who earn £29,000 per year, probably. I do know from my own life and experience and our economic research team, a lot of people outside London do not earn £29,000. For a lot of people, it's going to be a struggle. The rules are the rules. So we say, the law is the law is the law, but we have to go by the rules as they are. There are some sort of softer, different parts of the rules. If you don't earn 29,000 or you and your partner don't earn 29,000, there are some softer rules. Sometimes these rules are very, very difficult to make them work. For example, there is a rule that if there are exceptional circumstances, which means what it could mean, there will be unjustifiably harsh consequences if somebody didn't get granted their visa or get granted leave. If the Home Office think that that is the case, there's a sort of softer rule, exists somewhere else. Third-party family members, even friends, could offer to make a contribution if these exceptional circumstances exist. Perhaps that could be acceptable. I'm not sure how easy that might be. First of all, the third party would have to show a good standard of proof that this money is genuinely and reliably available. Could be difficult, not impossible, but probably difficult. There are other rules, even if there isn't any third party who can contribute. Possibly, again, this sort of unjustifiably harsh consequences, exceptional circumstances. Home Office could grant an application anyway, but I mean, these facts would have to be very, very strongly proved. If you look at the Home Office published policy guidance, you don't get many good clues to it. If you look at the decisions from the courts, the case law, most of them are unsuccessful. This looks like a very difficult area of law. You're going to have to be very lucky or have a very strong case to succeed. But one thing, there is a part of the rules, it's called paragraph EX. Again, some of it is very hard, but one thing that we know from published policy guidance and from our own experience, if there are children involved, the case becomes much stronger. If you're trying to prove the case on the basis of the relationship with the person, so our relationship is very true, strong, and genuine, and we have incredibly harsh circumstances, it's going to be difficult, but maybe you could succeed on a good day. Depends on which Home Office caseworker you get, like everything. If there are children involved, it works a bit differently. You can show that it wouldn't be right or fair to uproot the child from their life in the UK. Let's say one partner is in the UK, another partner is outside the UK. If the partner outside the UK couldn't get to the UK, the parent of the child in the UK is going to have to make a very, very difficult decision. Do they just stay in the UK and be separated from their partner, or do they want to uproot their child and take the child abroad to be with the partner? Experience shows us that where there is a child involved, the case becomes much, much stronger. I would say this, you have to be aware of these things. We can prepare applications for people. Sometimes we know it's going to be very, very weak. There is a rule or a law, it's actually from the courts. Decision makers, Home Office decision makers, or if it comes to the immigration tribunals, they have to bear in mind that the interests of the child are strong. This comes in international treaty, also comes in British law. It's called a Section 55 law. Section 55, a particular act of Parliament, says that the interests of a child in the UK are a primary consideration. A primary consideration, not the primary consideration, but a primary consideration. It's a strong card. If you're playing cards, it's a strong card. And Home Office policy guidance goes further. They say that this spirit needs to be engaged when a child is outside the UK. So actually, the Home Office policy guidance takes it further, stronger than the law. So when there is a child involved, we know from our experience that case becomes much, much stronger. We're being very honest with you here, like always. If there's no child involved, it's going to be difficult. If there's a child involved, it can be easier. Whatever happens, we will give you the most honest advice about your case. If you make an application into the Home Office, it's refused, you have the right of appeal to the First Tier Immigration Tribunal. Immigration Tribunal may be more sympathetic than the Home Office on a good day, on sort of an average. Really, these sort of cases are very fact sensitive. If you have such a case, you can contact us ask us. We will give an honest appraisal and assessment what we think about the potential strength of your case. Mr. Shah, I can see you have some questions for me.
Yes, please. Thanks a lot for explaining all of this in such depth, and it's very much needed, especially since this new changes have come into place.
I think, Mr. Shah, a lot of people, they can't meet the formal requirement, the normal requirement, so they're going to have to try and find different ways.
Alternative ways. I would like to reconfirm that if there's an applicant to apply for a spouse or a fiancé visa, and there are children involved, could be 1, 2, 3, or more, the financial requirement stays at 29,000.
Yes, that is correct.
Perfect.
You could have 15 children and it's the same. So it could work out cheaper for some people.
For some people. Okay. And anyone who may have made an application for their spousal visa before 11th of April 2024, they don't have to meet this new requirement.
They have to meet the old rule, which is the 18,600 plus extra for any children.
Okay.
And also, someone who's applied for a fiancé visa and it was granted, and it's successful, they, before 11th of April, they will have to meet the old rule, not the new rule.
Fantastic. Good for them. And even for spouse visas, anyone who may come to the UK very recently or may be coming in the future based on old rules, for their extension and ILR, they will follow through 18,600 route.
Yes, that's correct.
Perfect. Now, you mentioned that everyone may not be earning £29,000 a year.
Do you, Mr. Shah? Be honest. He doesn't answer. You work in London, but
I'll tell you in the pub.
Very possible. I think you lived in Birmingham or South Wales or north of England, then your answer might be very different.
Yes.
Everybody knows salaries in London are much higher.
Yes.
I mean, property prices are much higher, but everybody knows salaries in London are far higher than everybody else in the whole of the UK.
That's true. If somebody wanted to meet the financial requirement through their savings, has that amount changed as well?
I'm afraid it has. Do you really want to know the figure? It's horrible.
Oh my God. Just for the sake of the audience.
Yes, of course. Under the older rules, let's say you didn't have any eligible earnings, which might be. If you had savings in the bank, which you had there for at least 6 months, you had to show that you had at least 62,500. Now it's 88,500. It's a bit of a jump, really.
Wow, that's a big jump.
I mean, it could be in between. You could have some eligible earnings and some savings, but if there are no, to put it in perspective, if there are no eligible earnings, that's how it comes.
I understand. And just to make it a bit more clearer for our audience, would I be correct in assuming doesn't matter if someone is employed or self-employed as a taxi driver, or they may be receiving rental income, the financial requirement is the same now? It's £29,000.
Yes.
Okay, perfect. I think that's all for today, and I thank you for today's vlog.
My pleasure.
And
as always.
Thank you, and we see you in the next one.
See you next time. Goodbye, everybody.